Welcome to Chapter 8 of Law in Australian Society, which looks at criminal offences. In this chapter you'll learn about what is a crime, different types of crime, and when somebody is guilty of a crime. So what is a crime? Crime is something a person does that attracts a penalty under the law. So crimes are defined in legislation, which specifies the conduct required and the relevant penalty. For example, Section 409 of the Criminal Code in Queensland says that a person will be guilty of robbery, which is punishable by 14 years imprisonment, if they steal something while using or threatening violence. I say sometimes fails to do because occasionally it can be in a criminal offence to omit to do something, but this is rarer. This is a very legal way of defining what a crime is. A crime is conduct that is called a crime under the law. But the bigger question is, why is some conduct considered a crime? And then we have to get into more philosophical questions about what is a harm or what is morally wrong. So it seems quite obvious with crimes like murder or robbery or sexual assault that these acts are harmful and they are morally wrong to steal something or to harm somebody else. But at the fringes of the criminal law or for other contentious social issues, this can become quite difficult. So debates about euthanasia, for example, relate to whether it should be a criminal offence to assist somebody to commit suicide or whether that should be permitted by the law. Drugs is another tricky area. Lots of people believe, for example, that marijuana use, whether just recreationally or for medical purposes, should be allowed. But drugs also cause lots of harm to society. They can cause harm to individuals if they take too much, but it also takes a wider toll on society by adding to health costs, increasing criminal behaviour, and causing a breakdown in relationships. For all these reasons, drugs are heavily regulated. There are lots of different types of crime that are defined in legislation. Homicide means the unlawful killing of another person. This includes murder, intentionally killing another person, and manslaughter, which is unintended or negligent death. There are many different types of assault. Assault essentially means physically harming somebody, and this could include an aggravated assault with a weapon, or sexual assault, or many other kinds. Property offences refers to a range of offences for stealing things. There are separate offences for vandalism, but when we say property offences, we mean offences like theft, robbery, and fraud. We mention drug offences, and these apply to drug use, possession, supply, or on a large scale, trafficking internationally. Offences against the state include treason, espionage, and terrorism. There are public order offences, like using offensive language or being a public nuisance. There are road traffic offences, like driving dangerously. And there are environmental offences, which could apply to dumping large amounts of chemicals in a body of water. A person will be found guilty of one of these offences when the physical and fault elements of an offence are established beyond a reasonable doubt. The physical elements of the offence are the physical conduct involved in doing the crime. This is also known as the conduct elements or the actus reus, which means guilty act. So for example, in a murder trial where a victim was stabbed to death, the physical conduct involved would be stabbing the person with a knife. The fault elements, on the other hand, refer to the state of mind of the offender involved in doing the crime. This usually equates to an intention to do something. So for our example, it would involve intending to kill the person with the knife. However, the fault elements can also mean recklessness or having knowledge of something. These are also called the mental elements, or mens rea, which means guilty mind. If you're just starting your study of the criminal law, it might seem that crimes apply when somebody completes a criminal act. But it's also important to remember that there are offences for attempting to commit a crime or conspiring with others to commit a crime. So attempting to commit a crime involves starting to do the actus reus and then being interrupted for some reason. So for a charge of attempted murder, this could involve firing the gun at somebody and missing. Conspiring to commit a crime means agreeing with one or more other people to commit a crime at some future time. This can be difficult to prove in court, but it can involve intercepted phone conversations, written plans, or other documents that help to prove a plan to commit some criminal act. One person can also be found guilty of being complicit in the commission of crime by another. We say that they aided, abetted, counselled, or procured the commission of an offence. So for a murder case, if somebody supplied the weapon that was later used to kill somebody, that first person could be found guilty of aiding and abetting the offence. Defences in the criminal law relate to whether somebody should be excused from or justified for committing a crime. And these apply in very specific situations. Self-defence applies where they are acting under a reasonable belief that they or some third party is likely to be killed or seriously harmed. So for example, in a home invasion, the homeowner might intend to kill an intruder, but they do so out of a belief that they themselves or their family are likely to be seriously harmed. In that case, the homeowner could be found not guilty of murder on the basis of self-defence. Provocation is a defence which reduces a murder charge down to a charge of manslaughter. For this reason, it's called a partial defence, whereas self-defence is a full defence, meaning the person will be found not guilty. Provocation applies where a person kills somebody else in a fit of rage. This is where they lose self-control and are provoked to kill the person. There's debate about whether this is outdated because it excuses people for having hot-headed reactions to different situations. There are other defences which apply to somebody's mental state. Insanity, for example, applies where somebody cannot understand what they are doing or cannot understand right from wrong. This actually sets a very high bar and leads to a special verdict where the person can end up in mental health detention. Substantial impairment is a similar test to insanity, but it relates to whether the person's capacity to understand right or wrong or understand what they are doing is substantially impaired. The key points from this chapter are that crimes are specific types of conduct that are defined in legislation and attract a penalty under the law. Major categories of crime include homicide, assault, property offences, drug offences, public order offences, and offences against the state. A person will be found guilty of a crime when they have committed the elements of the offence beyond a reasonable doubt. This includes the actus reus, or the guilty act, and the mens rea, a guilty mind. Some discussion questions for you to consider in your lectures and tutorials. What are some of the reasons we should consider conduct to be a crime? What are the major categories of criminal offences? If you think about the law of assault, why do boxers not face criminal penalties for punching their opponents? What are the different elements required for stealing, robbery, and fraud? And these offences are looked at in more detail in the book. Why should possessing drugs be a crime? What about selling them? Can you think of any harmful activities in society that are not considered a crime? What's the difference between actus reus and mens rea? What is inchoate liability? Do you think a person should be punished for doing something even if no harm is caused to others? Do you think somebody should face a lesser penalty of manslaughter rather than murder if they are provoked to kill someone? And finally, at what age can a child in Australia be held criminally responsible? This is also looked at in more detail in the book.